List old matter item number 1.
My lord, the matter relating to the regularization, my lord, that the portion the annexer 1, the order of tribunal, my lord, London tribunal, that the vacancy will occur, that he will be considered for regularization. That is the now vacancy is there, my lord. He is continuing till now. 3 years service now left, so that's why my lord should be direct to consider. And annexer 8.
Why are you filing a petition challenging the order?
No, I'm challenging the annexer 1 that the order passed by the London Tribunal in 15/12/94, my lord. They're directing to regularize the petitioner as if vacancy occur in near future, and they will be also paid for minimum wages, my lord.
So why are you challenging it? Are you agreed with that order?
But they not taking any action.
No, then you have to move in contempt, sir. When you file a petition challenging that order, then we can entertain it. If you want the order to be implemented, you don't file a writ petition.
But thereafter,
you file a contempt petition.
Liberty, my lord, maybe.
All right. Counsel petitioner seeks leave to withdraw the present petition with liberty to file an appropriate application seeking implementation of the impugned order of the tribunal.
My lord.
Disposed of is withdrawn with liberty is paid for.
My lord. Obliged.
None appears dismissed.
Item 3, my lord. The petitioner is challenging the order passed by the Central Administrative Tribunal dismissing the original application. In the original application, he challenged the selection of opposite party number 6 on 2 grounds. That opposite party number 6 is the son of the branch postmaster, and secondly, that opposite party number 6 was serving in a Sanskrit toll. For that reason, he is not eligible to get the post of extra departmental delivery agent. And since the petitioner was working temporarily in the said post, he prays to appoint him in the said post. For the tribunal, in the order, held that since the petitioner has not filed the certified copy of the voter list to show that he is the son of the branch postmaster, that voter list without certified copy is not acceptable. And he has not proved that he was the opposite party number 6 was serving in a Sanskrit toll. For that reason, the Central Administrative Tribunal dismissed the original.
All right. What do you have to show that you were?
That voter list is a public document. My solution.
You should produce it, sir. You can't put the burden on others. You have to produce it.
Pardon me?
If you are relying on a document, you have to produce the document. That's a very simple rule.
I produced the document.
No, you produce a photocopy, no?
Yes.
Not the original voter list.
No, my lord. In Annexure 4, I produced the voter list, copy of the voter list.
So why didn't you produce?
Pardon?
Why didn't you produce the original list, sir?
At that time, that was not available for that.
Subsequently, you could have. Even during the hearing of the case, you could have produced.
I did not produce.
Then we have only to see whether the tribunal erred or not. That's all.
Only on that ground. And the petitioner was appointed on temporary basis in the said post, my lord, previously.
See, in fact, respondents have also shown that respondent number 6 is not to be the son of respondent number 5. Yes, what do you say?
His appointment is purely temporary basis, and since last 14 years he has already been disengaged, and new appointment as per the formalities has been completed, new appointment has been made.
Okay.
And he is only claiming for some period he works, that amount has not been paid.
As per Annexure 3,
Only
I sought
72 days for.
72 days.
That is the only grievance, ma'am.
Why don't you disperse that amount at least? He's worked longer.
And let him file an application.
All right. The petitioner questions an order dated 6 November 2003 passed by the Orissa Central Administrative Tribunal, Cuttack Bench, Cuttack bracket CAT, dismissing OA number 310 of 2001. Paragraph. By the impugned order, the CAT negative the challenge by the petitioner, who had worked as an extra departmental delivery agent bracket EDDA on temporary basis of the Akshat branch post office under Danpur sub post office of Kendrapada head post office to the appointment of respondent number 6 and further seeking a direction to appoint him as the EDDA of the said branch post office in place of respondent number 6. Paragraph. As it transpired, the petitioner had gained experience of 72 days as working as a substitute of the permanent incumbent EDDA of the said branch, who had retired. Stop. The case of the opposite parties was that the candidature of the petitioner was in fact considered, but his merit position was at serial number 19. Full stop. The opposite parties also were able to show that the selected candidate, that is respondent number 6, was not a near relative of the branch postmaster, as was alleged by the petitioner. Paragraph. The CAT was not impressed with the allegation of the petitioner that respondent number 6 belonged to the same family as the branch postmaster and was unable to substantiate this since the voters list produced by him was not a certified copy and in any event did not show that they were in a single quotes joint mess, unquote. Full stop. Paragraph. Having heard learned counsel of the parties, the court is not persuaded that the CAT has committed any error in rejecting the contentions of the petitioner and his prayers. Paragraph. It is then contended that with the petitioner having worked for 72 days, he should be paid proportionately for that period. Full stop. Counsel for the opposite party states that opposite parties 1 to 5 states that if the petitioner makes an application for that purpose, it will be considered and appropriate orders issued within a period of 4 weeks from the date of making such application. The said statement is taken on record. The petition is disposed of in the above terms. None appears dismissed or non-prosecution. None appears dismissed or non-prosecution. None appears dismissal, not prosecution. Same, none appears.
May I please, Your Lordship?
Yes, Mr. Padi.
Here the tax effect is 14,000.
In view of the insignificant tax effect, the question of law is left open for decision in some other appropriate case. The STREV is disposed of.
Yes, my lord. Item number 9. Here, my lord, question is whether the transaction in question is a branch transfer or it's a interstate sale, my lord. May I take your lordship directly to the judgment of the tribunal, my lord, full bench, page 62. Right, it's a 3-member tribunal where 2 have the majority have held in favor of the assessee and there is 1 dissenting note. My lord. So let me kindly turn to page 65. Paragraph 4.
They've referred to 4 questions to this court, is it?
Yes, my lord. Basically, all these questions relate to whether the transaction is in question is a branch transfer or it's a interstate sale.
What is the transaction?
Let me turn to page 65.
Yes.
Paragraph 4.
Yes.
Having heard both the sides and after going through the material available on record, it is seen that the dealer has got its factory at Baleswar in Orissa, having its head office at Calcutta. It has got 7 branches throughout the country. Stock transfers are effected from the factory to different branches on receipt of requisitions from the head office at Calcutta. It manufactures standard product of different grades of high ferrosilicon and silicon. The inspecting officer of the intelligence wing visited Calcutta branch on so-and-so and Bombay branch on so-and-so, and after making inquiries about the business activities of the dealer, reported the dealer to have not actually effected any branch transfer. On the basis of the above report, the STO reopened the regular assessment completed on acceptance of branch transfer under Rule 10 of the CST Orissa rules, and the dealer having failed to produce accounts of different branches, excepting Bombay and Calcutta, completed the assessment expected, treating the entire claim of branch transfer amounting to rupees 8 crore some odd as sales in the course of interstate and commerce. However, it is found that the dealer produced accounts in respect of all the branches before the learned ACST, that's the first appellate authority, who is of the view that the dealer had not been given sufficient opportunity earlier for production thereof. Keeping in view the decision of the Honorable Supreme Court in the case of so-and-so, it appears that the learned ACST has examined such of the each of the questions to decide as to whether the same was in the course of interstate sale or branch transfer. It is further seen that the learned ACST has categorically observed that the of such transfer in respect of all these branches, and certain transactions of Bombay branch squarely come within the purview of the branch transfer in view of the decision of our own High Court in the case of so-and-so,
So this is a fair enough order, sir. Once the ACST has undertaken such a detailed exercise, why should we interfere?
The learned ACST, has in fact held that except the Bombay branch, all other branches, it is a branch transfer, But this.
Correct. So why should we interfere?
For that, I will only show one paragraph of the dissenting note. In fact, the dissenting note starts from page 72,
Yes.
The accounting member has dissented and he has dealt with the order of the learned first appellate authority. That my lord would find paragraph page 73.
Yes.
The second paragraph. The paragraph starts with investigating officers.
Right.
He has detailed out why it should not have been treated as a branch transfer and it ought to have been as an interstate sale. I only place 2 paragraphs. The investigating officers had also visited the Bombay branch and it was reported that they test checked 20 numbers of transactions with details. All these sales are found effected on the basis of purchase orders like nature of order, its number, date, which are found indicated in the invoice from dispatch advice raised by Baleswar registered office. It was also found that those stock transfer advice of Baleswar office bears the name of the purchasers of Bombay branch and in some cases, numbers and dates of sale invoice of the goods sold subsequently by the Bombay branch were found. The investigation, so my lord, essentially, and he has distinguished the first appeal order. May I place that paragraph also? My lord, may turn to page 75. Page 75. Second paragraph, in appeal.
Yes.
In appeal, the Lord ACS held the disallowance of branch transfer only to the tune of so and so, relating to Bombay transfer on the finding the goods were delivered to the purchasers just on the date of receipt of such goods from the factory. But in respect of claim of branch transfer, in respect of other branches, he deleted the levy of tax. So far as the claim of branch transfers to New Delhi, Madras, Faridabad, Ghaziabad, and Ahmedabad, as in recorded in the first appeal order, the learned first SCST examined the books of account produced before him first time and held those to be branch transfers on the following observation. So this is the observation he has quoted at page 75. Further, on examination of the copies of the stock transfer advice issued by the factory office and written there, it is seen that the mention that no mention is made of the names and address of the purchasers at the branch office, though the same are found noted on the copies of the stock transfer advices at the branch office. This leads to the view that the factory office not yet detected to have maintained any secret written codes at the time of branch dispatch to identify the purchasers at the branch office. Therefore, the recommendation of the branch office that such note is maintained after the local sale is completed for the sake of easy reference of tracing the consignment in case of complaints about the grade quality is accepted. So on this erroneous basis, he has also he's deleted the transactions in respect of other branches. He records that in the stock transfer, the names, the invoice names, date, and all these of the
Only one member, sir. The majority doesn't agree with him at all.
Yes, my lord. But the finding is that
That's all. This is not a finding, sir. This is only a dissenting no.
Yes, my lord.
Ah.
He records that in the stock transfer advice, the purchase order, purchase date, all these are mentioned, my lord. So it's a my lord. So at the on the stock transfer is made, the purchaser is identified, the purchase order is number is placed, and all facts are there, my lord. So it's a pre-existing sale.
The present revision petition by the state arises from an order dated 26 July 1996 passed by the full bench of the Orissa Sales Tax Tribunal, Cuttack bracket Tribunal, by a majority of 2:1, rejecting the appeal essay number 12 oblique bracket C of 1994-95 filed by the state against an order dated 28 February 1994 passed by the Assistant Commissioner of Sales Tax, Balashur Range, bracket ACST, partly reducing the assessment made under Rule 10 of the Central Sales Tax Orissa rules, for the year 1989-90. Paragraph. The revision is before us pursuant to an order passed on 16/12/1996 by the tribunal, referring the following questions of law to this court for its opinion. Reproduce the questions from 97 paragraph. Mr. Padi Learned, ASC appearing for the department, correctly points out that the question that is common to all the above questions, the issue common to all the above questions is whether the dispatch of the goods from Baleshwar in Orissa to outside the state by the SSC was in fact in course of branch transfer, or in the course of interstate trade and commerce? Question mark. The perusal of the majority view of the tribunal in its order dated 26 July 1996 reveals that the ACST had undertaken a meticulous exercise of examining the transactions by producing the stock transfer advice issued by the factory office. The ACST found that there indeed had been stock transfers in respect of several cities, and even certain transactions of the Bombay branch squarely fell within the purview of branch transfer. The majority of the tribunal was satisfied that the ACST had undertaken a meticulous exercise in arriving at the above factual conclusion, and that it did not require interference. Paragraph. Mr. Padi, learned ASC, however, referred to the dissenting view of one of the members of the tribunal to urge that the documents did not reveal that the documents revealed that there was perhaps an interstate sale which was camouflaged as a branch transfer. Stop. Having examined the order of the tribunal, including the majority and dissenting opinions, and having considered the submissions of Mr. Padi, the court is not persuaded that the majority of the tribunal committed any legal error in agreeing with the ACST on the issue of branch transfers by the SSC as claimed by it. Full stop. This is by and large a factual determination, and the view taken by the majority appears to be a plausible one. Consequently, the questions are answered in favor of the SSC and against the department. And the aforementioned order dated 26 July 1996 of the tribunal in essay number 12 bracket C of 1994-95 is not interfered with. The STREV is disposed of in the above tips.
Weekly list item number 10.
The tax effect is 5,000 somewhat.
All right. The tax effect being insubstantial, the question of law is left open for decision in the appropriate case. The STREV is disposed of.
Weekly list item 11.
11, my lord, it's 26,000.
All right. Same order 11.
Weekly list item 12.
It's a dealer's of the instant dealer man.
1,60,000.
Huh.
So we don't want to proceed, man.
All right. With the tax effect not being substantial, question of law left open for decision in some other appropriate case.
Right. Obliged.
The petition STREV is disposed of.
Obliged, man.
Weekly list item 13.
None appears dismissed non-prosecution.
Weekly list item number 14.
Defects not removed till now.
It's 2,000 somewhat, my lord.
All right. Insubstantial tax amount, the STREV is disposed of.
Weekly list item 15.
My lord, it's 11,000.
Same. 15. Right.
Weekly list item 16.
None appears dismissed non-prosecution.
Weekly list item number 17.
Defects not removed for over 14 years. What's the delay?
The delay is more than 365 days.
All right. Further, the delay is more than 365 days, which is unexplained. The STREV is accordingly dismissed.
Weekly list item 18.
Again,
Same man.
same in 18 also.
Weekly list item 19.
19 matlab the delay is 1915 days.
There's a delay of 1915 days, which is unexplained. The delay is not condoned. Accordingly, the application is dismissed and the CREV is accordingly dismissed.
Weekly list item 20.
Defects have not been removed for over 14 years now. Even the provision of law has not been furnished. Certified copy of impugn order is notified. The petition is accordingly dismissed.
Weekly list item number 21.
The memo is taken on record. Liberty is granted to withdraw the petition as prayed for. Both these petitions.
Weekly list item number 22.
None appears.
Your Lordship, item number 22, Your Lordship. Your Lordship, the present petitioner had filed a contempt application as his petition for regularization of the services had not been considered at that point of time, Your Lordship.
Now it's infructuous.
Your no, Your
All
Lordship.
right. With the passage of time, the petition has been rendered infructuous and is disposed of as such. All right.
Weekly list item 23.
None appears. Dismissal not possible.
Weekly list item 20.
Well, item 24, I'm in virtual mode.
Yes.
Of order dated 2/7/2009, the petition was filed for non-sanction of DNS allowance to the petitioners.
Right.
Notice has been issued, no shock cause has been filed.
My lord, my lord, my name may be deleted because I have been disengaged by Red Cross since last 2.5 years.
Your name is appearing for the opposite party.
CK Monty, Chandan Kumar Monty.
All right. The name of Mr. Chandrakumar Monty be deleted from appearance for the opposite party. What is the DA amount, sir?
My lord, from 2005 to 2011, the DNS allowance of the petitioners were not been sanctioned. That has to be calculated.
Indian
by
Red Cross Society, sir.
My lord.
So how is the contempt petition lying against them? What is the original order?
The original order is in paragraph 7, page number 4 of the contempt application.
This is only disposing of representation, sir.
My lord.
They've not disposed of your representation. No. They've not disposed of your representation.
No, my lord. Till date they haven't.
So if you don't do these matters on time, I don't know what's the purpose going to be served. Now you want us to direct them to dispose it off again. This person whom you implemented must have retired long ago, sir.
My lord.
We'll have to file a fresh petition finding out who's now the present honorary secretary and all that. Then we'll have to issue a fresh notice.
Present honorary secretary is Ms. CTM Sugna, IAS.
No, all that was asked to do is
My lord.
dispose of the representation.
My lord.
You have no instructions.
No, my lord, as I have already submitted.
So you
that,
will
my
have to
name
find
is
out
deleted.
who's the new secretary and file an amendment.
My lord. I'll file an
So
amendment.
Devdas says he'll ascertain who the present honorary secretary of Indian Red Cross Society Bhubaneswar is and file an application to amend the petition. That is request list of 4th July.
Weekly list item 25.
None appears to
Your Lordship, and Lordship is seeing the age of the petitioner 1 and 3. The Lordship may dispose of the application if the cause of still subsist. Whether they are alive or not, I don't know.
All right.
If any cause of still subsist, then
All right.
liberty may be given to.
Leave to withdraw the present petition. With liberty to revive it, file a fresh petition when any cause of action survives. Disposed of is withdrawn with liberty is paid for.
I am from the opposite party now.
Yes, sir. All right.
Weekly list item 26. Item number 26.
None appears dismissed on prosecution.
Weekly list item 27.
27 certified copy of the impugned order has not been.
Despite 11 years having elapsed, even a certified copy of the impugned order has not been produced. The appeal is accordingly dismissed.
Weekly list item 28.
28 and 29, 693 days delay.
The delay is 693 days. It is not explained properly. The delay application is dismissed accordingly. The appeal is dismissed. Both 28 and 29.
Weekly list item 30.
None appears dismissed now.
Weekly list item 31.
None appears dismissed now. Prosecution.
Weekly list item 32.
32 delay of more than 3 years.
More than
3 years.
3 years. There's a delay of more than 3 years in filing the present petition. The delay is not properly explained. Dismissed on the ground of delay.
Weekly list item 33.
33 certified copy not filed.
Yeah, certified copy has not been filed for more than 11 years now.
34 also same.
Appeal is dismissed for non-prosecution.
34.
Same in 34 also.
Weekly list item 35.
35 is 995 days delay.
Delay of 997 days. Dismissed for not on ground of delay.
36, 37, 38 and 39 in all these matters certified copy has not been filed.
Yeah, 36 to 39 certified copies have been filed for more than 11 years now. The appeal is accordingly dismissed.
Weekly list item 40.
None appears dismissed for non-prosecution.
Weekly list item 41.
None appears dismissed for non-prosecution. 41, there is a memo.
41, I am for the opposite party.
Right. A memo has been filed that stating that the appeal has become infructuous. It is disposed of as such.
For OP, the appearance may be noted.
Right.
Indian context.
Okay.
Obliged.
Weekly list item 42.
None appears dismissed for non-prosecution.
Weekly list item 43.
None appears dismissed for non-prosecution.
Weekly list item 44.
Item 44 it is infructuous.
Infructuous is disposed of.
Weekly list item 45.
Item 45 infructuous.
Infructuous disposed of.
I am for the opposite.
All right.
Weekly list item 46.
None appears dismissed. No possible.
I am for the opposite party.
Right.
Weekly list item 47.
Yes. I need some time to file counter.
This is the case. But a lawyer of this court has been arrested falsely.
Correct.
That I require to file the counter affidavit. I humbly pray your lordship to kindly come to page 55. Roman 10. The 2 lines I'm reading. The opinion number 1 along with other opposite parties being instrumentalities of the state. But there is no necessity to array them as opposite parties in person. Opinion number 2 to 8. They all have discharged their duties as per their official capacity.
No, but that in the context of wrongful arrest and
yes, no. They are admitting that their state opposite parties, they are instrumental of the state.
So if they don't want to file a reply, they don't want to file a reply. We can't compel them to file a reply.
Yes, so state will file a counter affidavit.
You've still not filed a reply, sir. I thought last time we took time for that.
Plus, I have received the Parawise comment. Some more documents are required because documents have to come from 2 different districts. Here, after acquittal in 2 cases, because the petition has been filed for compensation.
You see, Mr. Katkia seeks and is granted a last opportunity.
Last, fine.
Just file a reply on or before 4 July 2022. Rejoinder can be filed for the next day. We'll take it up on 1st August.
Plus, may I humbly pray, opinion number 2 to 8 may be considered in their official capacity.
Why, my lord?
I don't know why we should
Specific
say all
allegation
that.
against them.
It's up to them. They've been served. They've not appeared. It's up to them what they want to say. Right.
Weekly list item 48.
None appears dismissal not prosecution. Miss case, correct. Miss case.
Weekly list item 49.
That correction be carried out. The office note has been produced.
Weekly list item 50.
Miss case, none appears dismissal not prosecution.
Supplemental list fresh admission item number 1.
My lord, item 50, my lord, disposed of matter, what modification I have no knowledge. Who has filed this? Your lordship was disposed of this case.
Item 1.
May please, my lords. This petition, lords, I am challenging the order passed under section 148A(d), my lords.
Mr. Chimanka is for the other side.
Sorry, please.
This is Mr. Chimanka's matter.
No, my lord, sir. Mr. Tushar Satpathy, my lord, he's appearing.
Where is he? Not here.
May I just briefly take your lordship to the facts?
No, but he's not here, Mr.
Lordship may take it up after lunch.
We'll take it up after lunch.
Greatly pleasure.
All right. And the next one also?
Next one, the same, my lords.
That's all.
The husband and wife, my lords.
All right. After lunch.
After lunch.
All right.
Supplemental list for orders item number 3.
Please, your lordship. As per your lordship's order of the previous occasion, this respondent is to pay a sum of rupees 1 lakh by today, by 27th, but due to his deplorable condition, mother is suffering from cancer. He has not been able to arrange that money, and moreover, on the previous occasion, he has already given 1,500,000. His condition is very critical, and
you must file an application in advance, sir. This is not the way of taking the court for granted.
He is arranging monies. Milord, I pray for some time.
You have to, the proper courses, you file an application explaining the reasons and ask for extension of time.
Milord, these are the difficulties I am putting for the lordship.
You file an affidavit. No.
This, Milord, I will
file an affidavit.
Milord, I will file an affidavit.
No, but this will be at some cost. How much is due?
The wife.
No, I know. How much is due, Mr. Bali?
As for their version, they have to pay 5 lakh. Thereafter, will.
That's right. So how much more is he to pay? 3 more lakhs.
2 more lakhs.
2 more lakhs.
Outstanding.
You pay 1 lakh, sir.
Milord, he is arranging money. This is my difficulty I am putting forth. He is trying to make collection of that monies to deposit. In fact, the mother is the old parents, and he is working in a private farm.
He stand from the very beginning.
On the previous occasion, I have filed an affidavit stating the sources, income, etc.
What about the predicament of the appellant and
the appellant is serving.
Let him go behind the bar.
The appellant is serving, and I have.
We'll keep it on 9th May. You bring 1 lakh on that day. You say counsel for the opposite party states.
I pray for some more time.
No. 1 lakh you bring on 9th, sir. Counsel for the opposite party states that due to extreme difficulty in which the appellant opposite party is placed, he was unable to make payment of the further sum as directed by this court within the time stipulated. He prays for some more time for that purpose. A direction is issued that the appellant should honor before 9th May 2022 make a further payment of rupees 1 lakh to the appellant.
Your lordship may direct them to pay the cost. My client came across from Bhadrak to this place today. and he has to pay the cost.
She's a working person, and I am.
All right. All the more, she must have taken leave because she's working. Mr. Bali, actually, she need not be present, but anyway, that's all right. You say
if he failed to pay
the
the
respondent is directed to remain personally present on the next date.
Yes.
Yeah.
If he failed to pay, let him go behind the bar.
So that will not serve your purpose, Mr. Bali. You know that.
Because
All
he will go on continuing. He has
But it
already
won't serve your
remarried.
purpose.
He has already remarried.
All right. All right.
And where I stand?
All
The
right.
child and the
List on 9. List on 9. All right.
Supplementary list item number 4.
I please, Your Lordship. Your Lordship, I have already issued notice in that recall petition because the other connected writ application is prayer was something different. Here, this prayer is something different. That is why Your Lordship sent notice to the opposite party. I have sought the copies also. Your Lordship, kindly look to Your Lordship last order. Here, the question is whether the ad hoc period that the district judge, Your Lordship, kindly look to my prayer at page 13. Fast track court, that squarely covered by the judgment, and the Registrar General of this court has already made the recommendation in terms of the judgment of the Supreme Court.
What would we say 5th January? What did we say? You're asking for modification of an order dated 5th January?
Yes, that in fact, Your Lordship disposed of in view of the order passed in WPC number 10677 of 2018, the present petition is disposed of. But that writ application is something, prayer was different because in that case, the state government had returned back the proposal. Here, the Registrar General has made the recommendation in favor of the present petitioners in terms of the judgment.
Do you have a notice in this application?
Yes.
My lord, on last date, I was directed to, my lord senior was requested
Order is not scanned.
I have sought the copies already.
The 5th January order is not.
IA number.
IA number is. What we see is 1202 of 2022.
Yes, my lord.
You have got it?
Yes.
You can take instead because it's squarely covered by Your Lordship's judgment, that Supreme Court judgment. And in fact, the Registrar General, I've given that copy also, along with my IA number 16824 of 2021, the copy of the recommendation made by the Registrar.
But we already issued notice in this.
Yes.
Yes, my lord. On last date, Your Lordship.
All right. Mr. Das seeks some more time for instructions at his request list on 11 July, sir.
Ma'am.
All right.
Can it be called along with that record, WPC 10677 of 2018?
The record of 10677 of 2018 be requisition for the next.
Right. All right.
All right.
Supplementary list item number 5.
May I please? Here, my lord, application because of my default in appearance on 29th March.
Now, what is the main matter about it?
So far, the main matter is concerned, my lord, it's a matter where the government, my lord, has decided to give, my lord, the health facilities at the doorstep. That means in each and every hospital, irrespective of the fact of its local, my lord, where it is, in the district level, in the sub-divisional level, and in the also, my lord, or the root level, my lord. And accordingly, my lord, they consulted the OTT, my lord, and accordingly, plan and policy was decided, my lord, and where it has been directed that in each and every hospital, there will be a telemedicine center which will give, my lord, render assistance to the needy persons with a particular rate, my lord, which is fixed by the government, my lord. And accordingly, my lord, it was carried out for years. Thereafter, my lord, government changed the decision, and accordingly, by Annex number 7 has directed me, I continued the particular center for about a year, and thereafter, my lord, government has closed changed the policy, and accordingly, my lord, directed me to stop these things, my lord. I approached the Supreme Court, and my lord has kind enough to grant me interim order, and till date I am continuing. In the meantime, my lord, because of that challenging that particular decision, the policy decision, my lord, some persons have approached the Honorable Apex Court, and the Honorable Apex Court in a particular case, my lord, has directed giving interim protection to the persons who are continuing, directed that the both writ application to be disposed of by the Honorable Court, my lord. The order was passed in SLP number.
Yeah, I'm handing over the copy of the order dated, Lord.
And 2 cases, my lord, it was disposed of by the Apex Court on 15/7/2019, directing the Honorable Court to take a final decision in that particular 2 writ petition, my lord. That is writ petition number 17691 of 2015 and writ petition number 98863 of 2018, my lord. And thereafter, my lord, in the meantime, a letter has also been made.
So where is that pending? Is it pending still?
Yes, my lord, pending.
Lord, I'm just, your lordship may kindly see the last paragraph, Lord. The apex court has referred to two writ petitions, Lord. Page 4, last paragraph, page 4 of that judge order, Lord.
Yes.
WPC number 17691 of 2015 and WPC 983 of 2018, Lord. Lord, I'm just having the last order of these matters are pending, Lord.
Reason stated, the application is allowed. The order dated 29 March 2022 is recalled, and petition 12032 of 2015 is restored to file. In 12032 of 2015, list along with WP civil number 17691 of 2015. That's it. Whenever that
Yes, there is no interim order was never continued in those cases.
And 9883 of 2018. All right.
Supplementary list item number 6.
May I please, your lordship? Lordship, challenging to notice issued under section 148 of the Act beyond 6 years, my lords. In view of my lords order dated 24th January 2020.
Beyond 6 years, same order.
Lordship, during the pendency of this appeal, present petition, my lord 7953, NFPC National Faceless Assessment Order passed the assessment order as well consequential demand.
All consequential orders.
Two writ applications there. One is here challenge the notice, and thereafter challenge the order. Notice has already been enforced because our order has been
So
passed.
the order will automatically go, sir.
Yes, therefore, my lord, the notice which he has challenged, that has to be disposed
We'll put both these petitions together and dispose.
As you lordship.
Right. Put both the cost lists and say, in view of the fact that the impugn notice under 148 has been issued beyond 6 years after the expiry of the assessment year in question, in view of the order passed by this court in
209/2021, my lords.
Ambika and Steel. The impugn notice and all consequential orders are hereby quashed.
Deeply.
Right.
Supplementary list item number 7.
Well, this is covered by two of your lordship's order. One was passed day before yesterday, and another was passed in the month of October. That 1 day time, lordship will kindly see page 35, that so-called notice by the Faceless Assessment Center. Page 35, clause 3. Kindly submit your response through your registered e-filing account by 23.59 hours by 28. And
One day. One
yes.
day's time.
Hello?
1 day's time.
Yes, 1 day time.
You type and order the same line. Changing the date for the account. Allowed the same terms. All right.
That the order of assessment has to pass.
Yeah. The order of assessment is quashed. Correct.
Supplementary item 8.
Mallards. Here, Mallards, lordship will kindly see Annexer 6.
No, who's for the other side?
Yes, my lord.
Chimanka.
Yes,
my lords, lordship may kindly see under Annexer 6, a letter was issued by the Principal Commissioner of Income Tax Central Circle proposing to transfer the case from Sambalpur to Rourkela. I filed my objection under Annexer 7 at page 24. Now, without hearing me, he transferred that order jurisdiction from Sambalpur to Rourkela.
No counter file, Mr. Chimanka.
No, just I received file. Yesterday I filed receipt.
No, day before.
Yes.
And another thing, my lords, most pertinent point is, my lords, faceless assessment proceeding cannot be made in a case under section 153A and 153C. That your lords will kindly see.
All right. Notice, Mr. Chimanka accepts notice. Reply be filed within 8 days, adjourned of the next date. Till the next date, no coercive action shall be taken against the petitioner pursuant to the impugn notices. Bracket annexures 9, 10, and 11. No, impugn notices and orders.
Malice.
Bracket annexures 9, 10, and 11. Bracket. List on 19th August.
Extra copy में kindly given.
All right, extra copy.
Same also in 9.
9. Same.
Item 9 also same.
Same.
Only years are different. Most obliged. Much obliged.
22nd August. All right. 22nd August.
Supplementary list item number 9. Same.
Same, my lord.
Supplementary list item number 10.
April 10th. Lord, the lease was granted way back in the year 1974, my lord.
This is what 38B.
783 that proceeding was initiated beyond the statutory period.
That your lordship has already decided in Asahan's case, WPC number 33349 of 2011, that even the fraud is detected, even the limitation period that will not come into the responsibility.
No, here, my lord, that fraud was not detected. If at all, my lord, fraud was detected, the date of detection should have been reflected in the order, my lord. That is not there in the order.
That doesn't matter, sir.
Yes.
That doesn't matter.
Your lordship, in the instant case, my lord, the lease was cancelled on the ground that there was some material irregularity. That's why, my lord, lease was cancelled.
It's the same.
And that too, my lord.
This is Sukinda, is it?
No, my lord.
Bhubaneswar.
Khordha.
Right.
ADM Khordha.
That second proviso of 783, my lord, after 14 years, no proceeding.
No, sir, if there's a total fraud from the beginning, there is no question of all that, sir.
And in
that's
fact,
what we have held.
Yes, no, the impugn order in the
impugn order, your lordship may
clearly explain what were the procedures.
Other
that
than
was not
limitation on
followed.
merits, what is your defense?
No, that is the statutory provision.
Sir, other than limitation on merits, what is your defense?
Merit, my lord, I am belonging to ST person, my lord.
No. What is the document on the basis of which you're claiming? Do you have any document?
Yes. That documents have been placed before the competent authority on verification and on proclamation of notice.
That is what is found fraudulent, sir. You're coming back, you're going in circles. Those documents have been found forged or fraudulent.
The fraud has not been detected and neither reflected in the order itself.
No.
Yes, your lordship may kindly glance page annexure, my lord. Annexure 4.
Annexure 4, my lord, was passed in the year 1990. The petitioner filed the petition in 2011.
Yes, exactly.
So the delay in approaching the High Court has not been explained.
Yes. That apart, my lord, no notice was served, my lord.
No notice was served.
No notice, my lord, nothing, whatever the cancellation that was not
clearly says that had the opposite party perused the LCR. Page 26 of the writ petition.
That's why, my lord, LCR was called for, my lord. LCR was called for. In the noting, in the...
Has the LCR come?
Yes, my lord. The certified copy of that LCR has come.
Is there LCR? So what does the LCR show? Let us see. Service is complete. Which page? Party present, sir.
No party. No party was present, my lord.
Order sheet, sir.
Yes, that has been reflected in the order. That's why, my lord, LCR was called for. The petitioner has neither received the notice nor has been intimated in the subsequent occasion, my lord.
Which page?
In fact, I had just showed it to my learned friend, senior, my lord.
No, that Dhuli Naik has not endorsed his signature, my lord.
No. So, Madhav Naik, Mohan Naik, Lord, these two petitioners signed the paper, my lord.
Are they related?
No, my lord.
That I.
Only surname is same. They're not related.
No, not related.
Why would they all be involved in this case then?
Not in single case, my lord. Around 1,900 cases have been disposed by the ADM Bhubaneswar, and in none of the cases, my lord, notice was issued.
This is the only point, Mr. Das.
My lord.
Ah.
Lord, then, my lord, because the
Send it
LCR
back
which I have received, my lord, the LCR which I have received, my lord, doesn't clearly speak about, my lord, furnishing of notice, my lord. So,
All right. The LCR has been produced. It does not reveal that notice was in fact served upon the petitioner before impugn order was passed. On this short ground, it is set aside, and the matter is the order dated 30 June 1998 is set aside, and RC number 600 of 1998 is restored to the file of the Additional District Magistrate Bhubaneswar. Being proceeded with afresh in accordance with law, the petitioner will appear before the ADM Bhubaneswar along with the downloaded copy of this order on 1st June 2022. The RC will be disposed of within a period of 4 months thereafter. Till then, is there any interim order here?
No.
No.
They are in possession of the land.
All right. Petition is disposed of in the above terms. All right.
Problem.
Mr. Salvi is appearing in this.
May it please, Lord.
Yes, Mr. Sir.
Lord, your Lordship had been pleased to grant us order, and
Yes.
that your Lordship will find your lordship, just give me a moment. There is an application for modification.
Yes, yes.
If your lordship has that application, madam.
The order is at page 34.
Page 34 is the order.
It's at flag D, my lord.
Correct.
And if your lordship sees, the problem here is because IBM has not notified
Okay.
the sale price. And your lordship, please to note that starting from page 34, if your lordship notices my problem, para 7 is the submission. It's in a council appearing for petitioner submits without IBM fixing the average sale price. For the two grades, it's practically impossible to comply with minimum production requirements. And then, my lord, it was my submission that if your lordship marks that date 10th June 2020, that from 10 June 2020, we've been banging on about this, requesting the IBM to notify, and they have not done it. And the submission of the state is in para 12, where the state says that the rate below 55% iron must be taken to apply across the board to anything which is below 55. If you're way below 50, also you're 55.
Right.
Yes. There's an old joke, Marat. Somebody said it's chicken and beef salad. They said, what proportion is it? One chicken to one cow. Something like that. If your lordship sees in para 15, your lordship directed. Mr. Salve added that considering the completion of pleadings, it might take time in the interim to avoid the consequence. He will, without prejudice and on a provisional basis, clear the monthly dispatches by calculating and paying the amount to the state government at the ASP published of below 55 for both grades, that is below 51 as well as between 51 to 55. He states even if for some reason you're not able to physically dispatch 80%, he will nevertheless ensure that 80% will be done. And the learned advocate general said he did not mind as long as the matter was heard early. Your lordship said reply in 4 weeks, rejoinder before next date. He lists in 8 September. We are, my lord, edging into May of 2022. No replies have been filed.
Why is that, Mr. Mudli? Sorry, Mr. Parijat is here.
Well, it's for IBM to do it, Mr. Padi.
Oh, I see. Sorry. Yes, Mr. Pari?
Yes, my lord.
No reply till date?
But this IA has been received on 22nd April.
Not the IA. The main writ petition, you have to file a reply.
Well, the point is this: 55 downwards.
Yes. Let Mr. Salve finish.
I'm so sorry, Mr.
Yes, Mr. Salve.
Now, my lord, if your lordship turns to my interim application, please see where we have ended ourselves because of this. If your lordship sees page para 8 of my application.
At page 4, my lord.
On this low grade of iron ore below 51%, the petitioners would have realized 500 and 600 per metric ton. However, against this, the petitioners are making statutory payments of 3,546 per metric ton. For the period July to 2nd July, petitioner has made a payment of 71 crores in respect of the undispatched quantity of 324,000. Thus, although the petitioner has incurred the huge cost for mining and paid corresponding, it has realized nothing in respect of the undispatched quantity. The IBM notification setting out the average price for the month is attached. And a sample sale invoice of the petitioner for the grade below 51 showing price at 600 metric ton for lumps and 500 is annexed herewith. Now, therefore, our position today is we are selling at price and we are paying duty at 3,546. And IBM has not bothered to file a reply. The state is putting the ball in the
Mr. Salve, is it possible for you to furnish a bank guarantee or something?
My lord, may I submit, my lord? With all respect.
No, 1 minute, Mr. Pari. Yes, Mr. Salve.
My lord, I was therefore suggesting I will pay royalty on my invoice price. I will file invoice and I'll secure the balance on a bank account.
Correct.
And your lordship may direct them to file a reply, hear it in July.
Yes, Mr. Pari.
My lord, there's a problem there. Would your lordships kindly see page 239?
See, there is no connection between his selling price and what he's paying.
May I come? May I therefore show your lordship, not page 239?
Yes.
Now, if your lordship sees, my lords, iron ore is on the left, third column, bauxite, chromite, and then iron ore.
So below 55%?
Exactly, my lord. So therefore, below 55 is pegged at 55. And then it becomes 58 to 55 to 58. So my learned senior wants, and rightly so, because I am mining something below 55.
But everything 0 to 55 is below 55.
The point. Therefore, your lordship called upon IBM.
I know.
Do the needful.
Correct. So the IBM is not doing it. That's all.
My submission to your lordship is this. I will take instructions. Your lordship may call it after 2 weeks. And in the meantime, let IBM do something. Because we are bound by this.
I have no problem if my learned friend wants 2 weeks and your lordship direct IBM to notify the price within 2 weeks.
Well, Lord, unless until I not take instruction, I can't submit anything. But I am praying, my Lord, that lordship.
No, Mr. Pari, now that you're here, Mr. Pari.
Yes, my Lord.
You have to file first of all a reply to the petition.
Yes, my Lord.
That reply is not forthcoming.
Yes, my Lord. Within 2 weeks, you will file. Within 2 weeks, you will file.
Not reply alone is not enough now. Now you have to fix the price. Matters, my sister points out.
Have you filed in those? Have you
Yes,
filed
madam.
in any such matter your counter? Then you can file it. This also you can file it in. the
Definitely, we'll file the counter within 2 weeks, definitely.
But filing counter is only part of the issue, Mr. Pari.
But after, if lordship not satisfied, then lordship may pass.
May I put it this way, if your lordship don't mind. Your lordship may specially indicate that in the counter they deal with this.
All right. You say.
And we can take it up on a date suitable to Mr. Salvi.
5314 of 2022 notice. Mr. Parija accepts, Mr. Mudali accepts notice for the state, Mr. Pari for the IBM. Mr. Salvi points out that with the IBM not yet fixing the rates for iron ore grade below 55% FE.
So below 51%.
Below 51. Of FE grade below 51%. And also not filing the reply to the main petition. The petitioner is suffering.
My Lord, sorry, we received the Parai's comments. If lordship fix the 10 days also, we can file the counter.
All right. Severe prejudice. And cannot sustain the enormous losses on account of the huge differential between what the petitioner is paying to the state and what it is able to recover through its sales. Paragraph Mr. Pari states that he has received Paravai's comments and will positively file the reply both to the main writ petition as well as this application.
Yes, ma'am.
Dealing specifically with the issues raised in this application. On or before.
My learned friend said 10 days at 6th should be.
Yeah, on or before 6th May. Correct. 6th May 2022. Rejoinder that to be filed before the next date. We'll take it up on 13th. Is that all right with you?
But I was wondering if it could be a little earlier, say 10th or something.
All right, 11th?
But 10th is not convenient.
All right, 10th. 10th at 1 p.m.
Deeply obliged.
All right, 10th May, 1 p.m. All right. Yes, yes.
So fixed for 2 p.m. Item number 23.
Your Lordship, may just kindly peruse these are the submissions we've made before the
first
committee.
I may be
First we need to hear from Mr. Pari.
Lordship, may
My
also
lord,
take.
My lord,
I may be permitted, my lord. I am filing 3 intervention application.
We'll do that. One.
my lord, there is a minutes prepared. Mr. Naik is there. You will assist my court. My lord, sorry, I'm here. They'll it is a minutes on 27/4/2022. Lordship got it, man.
No, he's just bringing it.
I'm sorry, my lord. Neither memo is made. Just now I received it by mail. So.
So the supply through road transport 5,000 to 6,000 tons a day, which means 80 trucks, more than that.
More than that. Much more than that. Much more than that. And the collector, as I was submitting,
but the NALCO also was present to this meeting. So we'll accept this, whatever they have decided.
We can have a copy of that because NALCO also has not been supplied with a copy.
Sure. Not a problem.
You would like to?
I think this should be given to everyone. I'm very happy that this happened.
Yes, my lord. I just now received the same.
Yes.
It's my priority to give the enlightened the code.
So let me just read out what they've decided.
Yes.
Railways to maintain the supply of 58 to 60 rakes per day to Talcher coalfield area. MCL to ensure on an average of 0.8 rakes a day, one railway rake equals 3890 tons for the refinery at Damanjodi. The coal requirement of Anugul CPP would be met by a combination of supply through MGR road transport wharf wall system as per the following details. Supply through the existing MGR system, 5,000 to 6,000 tons a day. Supply through road transport, 5,000 to 6,000 tons a day. Supply through wharf wall, 1,000 to 2,000 tons a day. MGR system to be strengthened, repaired by MCL and NALCO so as to suitably increase the throughput further. So railways have also committed that 60 rakes per day can be supplied to the Talcher coalfield area. So the meeting had Secretary Mines, Secretary Power, Secretary Coal, Chairman Railway Board, CMD NALCO and CMD MCL.
Lordships might find, I don't know, I have to go through the minutes.
58 records.
What I find in
ask them to give me copies.
Yes, but what I find in the minutes, probably there is no supply through the rail. If your Lordships will see.
Through rail there is.
No rake on the rail.
Exclusive.
Only 5,000, they say 5,000 through MGR and 5,000 through road. And
wharf wall. There's a wharf wall system. I don't know what
which is also leads to finally to a road transportation only.
No, up to a point I think. Because the wharf wall takes it to the loading point of MGR.
Lordships, but then the usual rake there is no allotment. If your Lordships will find.
Yeah, but this is what has been agreed.
Your Lordship would allow us to
Can we furnish our reactions to this?
Yes, to this
report? And Lordship calls it on Monday. We'll furnish our reactions to the report, my lords.
Whether it's actually feasible.
Whether it's feasible, because your Lordship is examining the issue, my lord, it has to be feasible.
Yeah, you may want to say, but the point is, all of you have participated. You see, the participation is there, and the minutes have been drawn up. Let this work out. Let this play out for a while, and then if you have difficulties, come back. We won't dispose of the case. If that's your apprehension, we won't dispose of the case. But we'll give it a week. Let it work out for a week.
Deeply obliged, my lord. Can we have it on Monday? Just our technical. Your lordship is not there in town day after. Otherwise, my lords, we needed 24 hours to just
the Chief Justice's conference in Delhi.
My lord,
so
that is
not for anything else. That's also visual. Yes.
My lord, that is the whole difficult. Otherwise, we were praying for only 24 hours, just 24 hours to get back to your lordships. Let the arrangement continue for 24 hours. We have to get back to your lordship. That is the only thing we were to examine and get back to your lordships.
No,
this is a question of shutting down the.
No.
Overnight, my lords, we can't. The whole arrangement has to come into place. It will take some time also. It's not that overnight it will come in place.
Lordships, hear me, my lord. I'm appearing for Vedanta, my lord.
We'll come to you in a minute. We're now dealing with the NALCO issue. We'll come to you in a minute.
Very well.
See, the point is this. The meeting minutes clearly say that the following was agreed upon, right? So there is no dissent. There is no demurrer by anyone. All right.
NALCO is also here.
Yes. NALCO MD was here.
No,
the minutes have been recorded. We're simply going to reproduce the minutes. Let what is agreed in the minutes be allowed to work out. See, we can't have both our interim order and this. It won't work.
No. I'm only on a very limited prayer before your lordship. And it's a question of shutting down. This arrangement, can it start from Monday?
Can we presume, Mr. Palit? Can we presume that the MD of NALCO
Lordship has been extremely gracious.
Was really not concerned about the shutdown, but only its officers are shut down.
No, Lordship has been extremely fair and extremely gracious. Lordship has gone out of the way.
It's not about fairness and all that. See, we must trust. These are very senior people sitting together, and this is not a problem. They're looking at it from a larger perspective, right?
Absolutely.
Of a problem throughout the country. You're reading about it every day in the newspapers. See, beyond a point, if they have worked out a solution, you should let that solution operate. For you to point out it's not working, it should start working. You should not assume. My only request to you, don't assume this will not work. They have put their heads together. They've come up. We are not disposing of the matter. If that's your concern, we will take it up on Monday, but we will not have both our interim order and this continue. Let me just make it clear. We can't have both our interim order and this continue. That is not possible. Let this work out. By then you'll know. You have your internal discussions. You sit with your MD.
I was only suggesting, well, subject to what your lordships decides. I was only suggesting that this arrangement can start from Saturday. From Saturday.
No, we have already worked out an arrangement, and this is meant to start working right away.
At least 2 days stock, let it come, my lords. At least 2 days. Already booked. It's on the way.
It is already on its way. It's already on its way.
Your lordship's order is in the process of being complied. Let that be complied from tomorrow.
No, nobody's going to stop the rake which is already headed to your plant. Okay, that's not going to happen.
My lord, may I suggest one thing, my lord?
Yes.
What minutes they have prepared. On the next page, lordship may see they have given the outcome of operation.
Correct.
Railway to maintain the supply of 50 to 60 ranks per day to Talcher coalfield. And the system, last page, MGR system to be strengthened, repair the MCL and NALCO has to suitably. That will suffice their problem. Because they are worried that first stop.
He's worried about the short term, Mr. Pari.
Yes.
He says what will happen tomorrow, day after, and that's his worry.
Yes.
Exactly.
Yes. So that will suffice the what decision they have taken.
We'll simply, we won't dispose of the petition. We'll keep the petition. We'll simply record what has transpired, what has been agreed upon by everyone.
Yeah.
And say we'll take it up again on Tuesday.
Yes.
Let's take it up.
Yes.
Tuesday.
Yes, Lordships, this one thing, this
1 minute, sir. We are not yet.
Is one thing probably which does not come out in that minute, as your Lordships just read it. There are 127 rakes which have been booked. Payment has been made. They are e-auction rake, not concerned with the rake. They may also be
the
regularized.
Chairman Railway Board was here. He has agreed to supply certain rakes.
Yeah, even MCL has to cooperate on that.
One thing you should not presume. Okay, one thing you should not presume, Ms. Rath, I'm really making it very plain because you're insisting, I'm telling you this. One thing you should not presume that somehow your MD knew less than what you do. Don't presume that. We should presume he knows more than what you do, and his interests about NALCO is higher than what you can even ever imagine or Mr. Palit can imagine. That's why the MD of NALCO is sitting in that meeting. All right.
Can I have one submission, my lord? In the process of road transport, my lord, huge number, as your lordship by now the statistics are
See,
before.
we'll cross the bridge. We'll cross the bridge when we come to it.
No, only in the interim, I was only praying that the
you can bring this to the attention of the collector if you encounter any problems in transportation by roads. All right.
That may be observed in the order.
That's right.
That will take care of the issue.
That's right.
That will take care of it.
Oh, you see, pursuant to the order passed by this court, a meeting was convened at 12 noon on 26th April 2022, which was attended by the Secretaries, Mines, Power, Coal, the Chairman Railway Board, the CMDs of NALCO and MCL, and other officials of the concerned ministries. Stop it. The minutes of the meeting have been placed before this court by Mr. Pari. After discussion of all the issues concerning the coal supply shortage being faced by NALCO, the following is stated to have been agreed upon to meet the supply of coal to NALCO as per FSA provisions. Just take A to A. The court records its appreciation of the promptness with which the order passed by this court has been acted upon and a short-term solution arrived at in the above manner. Paragraph. In order to ensure that the above solution is implemented immediately, the court considers it appropriate not to continue the interim order already passed and to await the result of implementation of the above arrangement. Stop. Paragraph. There is an apprehension expressed that since a large amount of coal is required to be transported by road, there should not be any resistance faced from the local administration. Full stop. Considering that this is an emergency measure that has been thought of, and agreed upon by several of the concerned stakeholders, a copy of this order, along with the copy of the minutes of the meeting, be provided to the Collector Anubul, is it?
Collector Anubul.
Collector Anubul. For his information and action. Full stop. List on Tuesday at 2 p.m. Tuesday is
Tuesday should be.
Tuesday is a
Third is a
holiday.
holiday.
Yeah, Wednesday at 2 p.m. Wednesday at 2 p.m. Wednesday at 2 p.m.
Wednesday.
We were thinking of Monday.
The copy of the minutes be made available to counsel for NALCO as well as the petitioner, counsel to the petitioner.
We were thinking of Monday morning, Monday afternoon.
No. And you can always mention something if it is
My
urgent.
lord, regard to those intervention applications.
Yes. Now tell us about this
Yes.
intervention.
I am for the employee, my lord, association, 3 employee association, my lord, I am filing that.
All right. All these 3 intervention applications, you just say notice and everybody else accepts notice and list along with the main petition. All right. Yes, Mr. Mehta now.
Yes, my lord. May I request your lordships to take up the writ petition? I hope the paper book has come to your lordships, my lord. It's writ petition 10779 of 2022.
Right.
On behalf of Vedanta, my lord.
Right.
The situation is
Taken up along with the other two which was filed the other day.
Yes.
Also fixed.
That's connected with this, correct?
Connected with this.
What is your immediate prayer, Mr. Mehta?
An interim prayer, my lord. Your lordship will have my IA. Perhaps it will be at the end of the paper book, my lord. I have indicated what my requirement is, my lord. And I've indicated also in my writ petition, my lord, they are only supplying 15% of the, my lord, FSA.
So we'll only issue notice at this stage. Let them come back on Tuesday.
Only request is, my lord,
Wednesday.
My lord, can I just point out my coal reserves are only 3 to 4 days. That's why, my lord, your lordship, my lord, took immediate, my lord, interest in the matter and issued certain directions, my lord.
The other thing I can do, Mr. Mehta, is we'll have to take this up on Monday then. So if we take it up on Monday, it will serve your interest, right?
Lord, actually, it's only 3 to 5 days. Some respite, my lord.
No, it'll have to be either Monday. See, we'll have to give them time to respond. It'll have to be either Monday or Wednesday.
No, I understand, my lord. Monday, of course, I will take it, my lord. Whatever is suitable to your lordship. I was only wondering if some kind of interim order. If you
no, that not because you say you have 4 days time. You see, NALCO came at a very critical stage. So we'll just say notice.
I'm buying, my lord, 1,000 megawatt of power, my lord. I'm importing.
I know. Mr. Mehta, also see there's a difference between a private player and a public sector.
No, I agree. I'm not saying.
So we have to be conscious of that too.
I agree, my lord. But your lordship may also consider this the largest smelter, my lord, in India. And my lord, it has to run non-stop.
No, because you say this affects the livelihood of 40,000
yes,
direct and indirect employees. That's one reason why we are taking it up.
Yes, my lord, because
along with the other
ecosystem
and the revenue loss you say is 40,000 crores.
That's right, my lord, because if the smelter closes, my lord, your lordship knows, my lord, to restart it will take 12 months.
No. So we'll just say notice, Mr. Mudali, notice for opposite party numbers. You have supplied a copy to everyone, Mr. Mehta?
My lord, the railways and MCL would be the railway and MCL would be the more like the.
No, state of Orissa is anywhere there. So.
Yes,
but they have no role, Mr. Mehta. Actually, the state of Orissa has no role. So right now, we'll say notice to Union of India and Ministry of Railways, Railway Board, Southeastern. Okay. So Mr. Pari accepts notice for opposite party number 1 and 5 to 9.
But right? 2 is important. Mahanadi Coalfields.
No, Mahanadi Coalfields, Mr. Mohanty is there.
And my lord, also
Mr. Devraj Mohanty accepts for Mahanadi Coalfields, opposite party number 2. Coal India is who?
Millers. I think Mr. Mohanty can himself appear.
Coal India?
Yes.
All right. He accepts for Mahanadi and Coal India. All right.
And my lord, somebody will represent the railways, my lord. They will also.
No, same, Mr. Pari. Mr. PK Pari accepts for all of them.
Notice be issued.
Yeah, notice has been issued. And notice in the other 2 petitions, that is 10623 or 24.
And 424. 10424.
10423 and 10424. Just show me one of them. The opposite parties are the similar in those?
No, not similar.
Yes, ma'am.
It is 1 is Union of India, 2 Mahanadi Coalfield, 3 Coal India, 4 is State of Orissa, 5.
The State of Orissa leave out. Just say
5 is Ministry of
leave
Railway.
out State of Orissa. You say notice is issued to opposite parties leaving out Orissa.
5, 6,
then
7.
Similar people will accept. Railways and Union of India will be Mr. Pari. Then Mahanadi Coalfields Coal India will be Mr. Devraj Manji. And Vedanta will be the.
Will appear, my lord.
Yes. Mr. Nayak.
My lord, I'm sorry, my lord. I'm really sorry, my lord. I thought, my lord, your lordship may consider some kind of interim direction.
No. Let them come back on Monday. On this, let them come back on Monday. All right.
Your lordship will have it at 2 o'clock, my lord.
Yeah. So, Mr. Palit is here, or we'll take the NALCO matter also on Monday then.
Lordship, please.
We'll take up the NALCO matter also on Monday at 2 p.m.
I'll inform you.
Right.
Both Mr.
All right.
No, you started late today.
I'm grateful, my lord.
All right. But Mr. Mehta, you'll have to keep in mind that this is an all India problem.
No, I agree, my lord. I agree. But if you're
and as a private player, you must be able to buy coal from the market. See, PSUs are having that problem, but I don't think Vedanta should have that problem.
My lord, may I only explain, my lord, just give me a minute. My lord, I may only explain. I'm actually importing coal, but my problem is, my lord, I need indigenous coals. I can only blend up to a certain extent.
Yeah.
My equipment and, my lord, my machinery is geared up for.
No, I just thought you should anticipate this kind of a response whenever it comes. So you better be prepared for that.
Apart from that, only Coal India and the subsidiaries can sell coal in so far as India is concerned. No other private player can. We can't purchase from the private.
No, you can import from Australia. I suppose you are importing.
It has to be imported. But then the blend has to be different because for the indigenous, the factories have been made with those technology. So maximum blending can be maybe 10 to 15%.
See, the only way we can do is what we did earlier. The court can only step in up to a point.
Yes.
We can't.
Obviously, my lord.
We can't take over these functions.
We will neither want that.
It's only because, my lord, public interest in a sense.
No, that's why we're even entertaining. That's why, Mr. Mehta, we are telling you why we're entertaining, but there's a limitation to how much a court should and can do.
I bow down to that, my lord.
Legitimacy and competence.
Yes.
Lordship pleases, my lord.
Obliged.
Obliged, my lord.
Right.
May I be permitted to mention items 1 and 2?
Yes.
Subject to your lordship's kind convenience.
Correct.
Since my friend is there.
Yes.
Also. So item number 1, my lords.
Yes. This was again inadequate time, or
sorry, minutes.
This was again about inadequate time being provided.
No, no. Here, what has happened, my lord, is he issues me a notice under 148A, my lords, on a particular ground that I have undisclosed investment in purchase of land. I give my replies, my lord, that I have purchased the land from relatives.
1 minute. 1 minute.
Please, I'm sorry. May I continue?
Yes.
May I just please page 22, which is a part of the notice at Annexure 4 series, page 22, my lords. May I just read it, my lords? He says that you have purchased immovable property with a consideration amount of rupees 1,60,000 during the financial year 17-18 relevant to the assessment year 18-19. So you have made an investment of 1,10,60 in purchasing immovable property.
Sir. Yes.
Your lordship may kindly turn to page 22. Minutes.
Yes.
These are the reasons which he says he has inquired into under the provisions of 148A, my lords. You have purchased immovable property with a consideration amount of rupees 1,10,60,000 during the financial year 17-18 relevant to the assessment year 18-19. So you have made investment of 1,10,60 in purchasing immovable property. However, the ITR filed by you for the relevant assessment year, fixed asset has been disclosed as 0, loans have been disclosed as 0, the total income has been disclosed as 6,29,860. As you have failed to disclose the source of such huge investment made of 1,10,60 by you during the financial year, therefore you are required to show cause as per the provisions of section 148A(b) of the Act as to why such investment of so and so will not be treated as your escape income from other sources under section 147 of the Income Tax Act 1961 for the assessment year 18-19, and why notice under 148 will not be issued to you for the relevant assessment year months. Pursuant to that, my lord, I filed my response. That is at page 23, my lords. At page 23, my lord, I'll just place paragraph 1, my lords. Kindly refer. Your lordships are with me.
Yes,
my lords? Kindly refer to your notice under section 148A, date so and so cited above, issued in my favor, wherein it has been alleged that I purchased immovable property for a consideration amount of rupees 1,10,60,000 is not correct. Although I have purchased immovable property belonging to my husband's and ancestors, the consideration amount is 90 lakhs, jointly by my husband, Sri Girija Prasad Dutt, PAN number so and so, and the entire consideration money has been paid off the joint account maintained in the Allahabad Bank, Cuttack, bearing account number so and so, joint bank account copy and relevant annexed as marked as Annexure 1 minutes. Your lordship, I need not take, I enclose my TDS certificate as Annexure 2. Then I explain my source of 90 lakhs. Then lordship may turn over the page. I give my bank details. Then your lordship may come to page 25 minutes. I enclose a copy of the sale deed and I say at paragraph 5, thus the entirety of 148A notice is solely based on investment in immovable property, and the source of investment is out of my past savings, and the consideration amount of rupees 90 lakhs, which was duly paid to the vendors after necessary TDS as per provisions of the Income Tax Act 1961. This explanation is supported with documentary evidences like bank account of the SSE's husband and SSE jointly. And on the other hand, the sale deed instrument and the consideration amount is duly described. Copy of the sale deed is also annexed, my lord. Then I ask him for a personal hearing, my lords. At this juncture, my lord, I'll just place a relevant portion of the sale deed, my lord, at page 33, my lords. Your lordship would appreciate unnumbered paragraph 2.
No, tell us what has happened after
Lord,
that.
what has happened, my lord? He, my lord, even though he says that I have inquired into this and I have said that this 1 crore 10 some odd is your income, is your undisclosed source of investment, my lords, he accepts it at page 19. Then he goes on a tangent and says that 56(2)(10)(b) of the Act is applicable. Now, dear lordship may kindly come to page 19, which is the order which I have impugned.
So all that has happened now is this: he's now going to issue notice under 148.
Lord, he has issued notice, my lord. What I have said, my ground
I'm
is
just saying this is like a GK and drive shafts.
my lords. What has happened? What has happened, my lord,
Okay,
is
because
no. What has happened? No, your lordship would appreciate this particular aspect, my lord. Your lordship knows, my lord. Section 56(2)(10)(b) will not apply to relatives.
No. That's the merits. No, I'm just on this. We are now on still a compliance with a certain procedure.
My lord.
So what the Parliament has done is put it into the statute. Put GK and drive shafts procedure into the statute, which is why 148A. Now, if we start interfering even at the stage when a rejection of a 148A, that is rejection of your objection.
Well, why I say so?
Then we start having several rounds of litigation.
Why I say so, my lords? First, no chance of hearing, my lord.
No. Now, when 148 is issued, you'll again go before.
No, he has directly made. What has he done, my lord? He has applied the wrong section, my lord.
It's okay.
Now he has asked me to file returns. For a moment, my lord.
No. So it only takes you to the point of responding to the 148. It only takes you to that point.
Lord, it takes me to that point because of this order at page 19, my lord.
Correct.
Lord, had he
So you reserve. I'm saying if it ultimately results in a negative assessment order to you, where your assessment is reopened, you're asked to pay more tax. When you challenge that, you can raise all these issues then.
No, that will be in an arena where my humble submission.
You're not going to be foreclosed.
No, it's true, my lord.
Nobody will foreclose all these submission of yours.
No, what has happened?
You will have an additional whatever in weapon in your armor.
My lord, he proceeds, my lord, that this is my undisclosed investment. Then he gives up that. So the entire edifice in which 148A was initiated falls.
You may be able to convince the assessing officer.
No, why I can't? Because he has the approval of the Principal Commissioner of Income Tax.
So we can. The most clarifier is notwithstanding. We'll say notwithstanding his rejection of your objections.
No, may I just humbly?
He may independently consider the issue.
May I humbly submit
the assessment?
May I humbly submit, Lords?
Yes.
Let him hear me in person.
Not necessarily.
Because otherwise, Lord, what has happened, Lord, is 148A, Lord.
We're making it all within the procedure, another procedure, and another procedure. It's an endless exercise.
The language of 148, my lord, which had prevailed upon your lordship to issue notices in the other cases, my lord, is 148B, my lords,
Right.
which I've quoted at page 9, my lords. Your lordship will take
Let's
up
see page 9.
Page 9, my lords.
All right.
That is why the other batch of cases which have been put to 10th of May, my lords,
Right.
it was precisely on this point that after conducting an inquiry, if required, with the prior approval of the specified authority, with respect to the information which suggests that the income chargeable to tax has escaped assessment, B, provide an opportunity of being heard to the assessee with prior approval of the specified authority by serving him upon him a notice to show cause so and so. So no opportunity of hearing has been given, my lords. And what has happened, my lord, is he is applying a provision of law, my lord, which is not at all applicable to the facts situation to the case, my lord.
Yeah, remember GK and drive shafts, they only had to give you a show cause notice and they had to consider your objections, right?
True, my lord.
That was GK and drive shaft. I don't think there was any personal hearing at that stage.
True, my lord. But legislature, my lord, in its wisdom, has introduced this word heard, my lords, in B. Even though for the gist of 148A is GK and drive shaft, my lord, the ratio laid down.
The adverb personally is not there.
No, my lord. My lord, once it is heard, my lord, once your lordship knows it has to be an effective hearing, my lords. And your lordship, if your lordship would be with me, my lord, if it allow me to place
the hearing has to be of the spoken voice.
My lords, with great respect, my lord. My lord, it has to be, because your lordship would appreciate the sale deed says my vendors are my relations. 56 to 10B, if your lordship would kindly
that's
take
all merits. No, that's not the merits.
No,
They're really purely on
what he's
procedure.
done, my lord, what he has done, my lord.
Mr. Karel, let me be very clear. I don't know. 1 minute. Yes, what's your response to heard, opportunity being heard? That has to be given meaning, right?
He has filed a petition, Lord, in response to 148.
Correct. He has filed a objection. Let's go back.
That has been considered.
No. What it says, the section, come to page 9.
Lord, I marked it, Lord. I have marked it. Being heard.
What does that mean? Why should the legislature say that?
Yes, that's not.
So let it go back. If there's been no hearing, let it go back.
Lord, may give some one now. So that instruction
sure.
is issued.
No, we'll fix a date on which he appears and you hear him and pass an order. But you have to pass again an independent order, not the same order that you passed. Then that will become a mechanical thing.
No, Lord,
if you prejudge, then he'll say, what is the point in being heard?
Lord, one point he has been, Lord, what part of 148 now is over. Now is in 148 has been issued.
No, 148A. This is 148A.
Yes.
This internal page 9 is 148A.
Yes.
That's not over because 148A required you to hear him.
Yes.
And you have not heard him.
Lord, that I take instruction because first time is
No. Where's instructions? He's saying you don't know whether he's not been heard.
Sorry, Lord.
You're not aware whether he's been heard or not.
No, Lord, I checked not one petition has been filed. Right. And that petition
one of the contentions raised is that there was no hearing afforded to the petitioners as required under section 148 capital A small b of the Income Tax Act 1961 prior to rejecting the petitioner's objections pursuant to the show cause notice issued under that provision by the assessing officer. Mr. Satpathy states that he'll have to seek instructions on whether in fact such a hearing was provided. List on. They have a short date then. How long will it go?
1 week after. 1 week after.
11th May?
Yes.
All right. List on 11th May. Till then, no further steps be taken by the opposite parties pursuant to the impugned order.
What has happened, Lord? I'm sorry, I'll just take 2 minutes. This approval from a specified authority has been done away with with effect from 1/4/2022.
Correct.
Reason being, my lords, this was closing an avenue because they were taking, the authority was the highest in the administrative line, that's the principal commissioner. So that was shutting out our chances of 263 approaching him in a revision. Appeal, my lord, will not lie against a 148A order. So even if he passes a wrong order, it's only your lordships to whom you can approach, my lord.
Say every time they try to plug something, they open up to other avenues. So that's what is happening in law.
And what has happened, my lord, your lordship would be surprised if your lordship would permit me.
Basically, we are all kept busy.
No, now, my lord, there has been a mad haste, my lord, to issue these 148 notices, my lord. With great respect, my lord, I may say so, that this old adage, my lord, of a honeybee collecting nectar without affecting the flower has been done away with. But at the drop of the hat, my lord, your lordship would see this case, and if your lordship would permit
only persons not unhappy are the lawyers.
we can express our anxiety for the clients, my lord, as well as my lord.
All right.
Item number 2 is the same. There's a husband, my lord. So same order may be passed.
Yes, same order.
Greatly obliged.
All right.
Supplementary list item number 11.
My lord, kindly see order dated 21 to 22.
Last
Yes,
occasion,
last
I am
occasion.
directed to file the affidavit. So though I have sought for instructions, I have not received. I feel some more time to file the affidavit.
2011 matter, Mr. Mudri.
Hello, this affidavit was filed in the month of February 2020.
All right. Mr. Mudri seeks and is granted a final opportunity to file an affidavit. On or before 1st July. 1st July. Oh no, that's open before July 2022. Response thereto, if any, before the next, we filed before the next. 2nd August.
Totally.
Supplementary list item number 12.
Your lordship, these 2 date charts. Your lordships, I'm a power plant, your lordships. On Annex 3.
This is that water.
Your lordship will look at page 32. Yes, I've entered into.
No, by now, he must have got instructions.
So I have not received. I have communicated the order, but I have not received any instructions.
I'm already enjoying a stay order. The thing is, there is a stay in my favor. Your lordship will look at.
No. So what was the order that we passed?
Your lordships, they have actually, by way of a resolution, come up with a fund called Water Conservation Fund.
No. What is the order that we have passed? One minute.
Your lordships, your lordships is not audible to me.
Oh, sorry.
No.
What is the order we have passed?
Your lordship, that is on 17.
So we have asked them to postpone the date of the signing of the agreement.
Yes, your lordships. But that arrangement is making me pay 20 lakhs per month. So it's almost they'll get the same money.
Where is it per month? Some few days it's going by.
Lordships.
Not per month. We're not adjourning it by a month. How long for you to take instructions?
No, so far as counter is concerned, counter already we have.
No, instructions. See, her thing is, you're forcing her to sign an agreement by which she ends up paying much more than she needs. She doesn't need so much water.
Yes.
And she's saying she wants a lesser quantity also.
Yes. On the IA, I will take instruction. The Lordship may grant 10 days time.
Your lordships, that paragraph which that paragraph which I want to be stayed in the agreement has already been stayed by this court by order dated 31/7/2017 in this very matter.
And
in
then
my previous
the second point she's making is several others have already been granted a full stay.
Stay, your lordships.
That is there. 31/7/2017. I have noted that the demands will not be pressed against the petitioner.
Your lordship, but they have re-remanded the same amount. When I'm going for a.
See, I think if you take instructions on the reduced demand from 24 to 20 Q6.
On the IA, I will take instructions.
That's what they want. The reduction from 24 to 20.
That they've agreed. But, and I have just have to sign a Form K, which is statutory agreement, But they said that before you sign that agreement, they have said you pay that much of money, which doesn't have a backing of law, neither of that act, neither of the agreement. I mean, the statutory agreement. So that demand actually has been published in form of a gazette notification, that water conservation
Anyway,
fund.
so the date of signing of the agreement is anyway being postponed.
Lordships.
You say, Mr. Mudali just put down this IA number 5076 of 2022. Mr. Mudali, appearing for the state, seeks some more time for instructions. In that view of the matter, the interim direction issued by this court on 22nd April 2022 is continued till the next date. 12th May, list on 12th May. All right.
So can it be 11th maybe? 11th.
11th May. All right. 11th.
Supplementary list item number 13.
Challenge the impugned order by the annexure 2 dated 22/3/2018, page 21. The OP number 4, he is directed to the Tahsildar for allotment of the Gochar land for construction. Gochar land cannot be transferred.
No, but what has happened? Was there interim order here?
No, there is no interim order, but there is no construction.
Then why?
And they have, my lord, they have filed.
On their own, they have stopped the construction then.
My lord?
On their own, they seem to have stopped construction.
Yes, my lord, the collector has a filed counter. But see, for the moment, page 36.
Yes.
Paragraph 9.
SMS Gochar.
That it is reply averment paragraph 6 of the repeated submitted the Kisam of land is the Gochar classification.
The reservation has not been processed. That's your thing is served. The purpose of your petition is served.
Yes. Thereafter, I see paragraph 12. The site selection meeting proceeding has not been approved by the collector. The dereservation case record has not been started. So, question of issuance of notice as required under section 4.1 does not arise.
We'll just record these two paragraphs and dispose it off.
Yes.
You see in the
and they have violated the rule 4 of the Ujira.
Where's the violation? There's no construction, sir.
The de-alienation process has been stalled due to pendency of this case.
You see,
they have not initiated.
In paras 9 and 12 of the counter affidavit filed by the opposite party reads as under paragraph. Considering that no construction has taken place and the process of de-reservation has not even commenced, the court does not consider it necessary to issue any directions at this stage, other than requiring opposite parties to give sufficient advance notice to the village in question in case a de-reservation process is hereafter sought to be commenced. The petition is disposed of that above that.
Supplementary list item.
One sentence, direct to follow the rule 4 of the Ujira Act.
So we don't have to tell people do not disobey the IPC, do not disobey the law. Please abide by the constitution. We should not be saying those things. We are supposed to know all of this. All right.
Supplementary item 14.
My lord, is the PIL about water bodies in the Cuttack city. My lord had asked for a detailed status report of water bodies in the city that has been made. I have received the report. Out of 66 water bodies, less than 20 are actually fit for community use. If my lord gives me some time, I'll file the affidavit and place the report.
Yeah. You say Mr. Devishish Naik, learned counsel appearing with the CMC, states that a report has been prepared of the water bodies in Cuttack city that are capable of being revived.
Out of 66 water bodies, less than 20 are fit for community use.
Of the water bodies that are fit for community use. he states that he will place the said report along with an affidavit within 2 weeks.
My lord.
I have
With
got
an advance copy to counsel to the
I'll do that.
I have got small submission with your lordship that this subject matter has already been decided by this honorable court, by their judgment dated 11/10/2012. In a judgment, it has been already, I would like to.
See, if there's already a judgment, are you saying please do not give any more orders?
No, already covered.
If there's already a judgment, you don't want us to pass any orders then? We'll simply say, you say there's already a judgment, we'll close the petition.
No, my lord. I want to submit before your
Let him
lordship.
first give a report, then we'll look into all that, sir. Let him first give a report.
Then the judgment will be taken into consideration.
That's right. On the date when we are hear full-fledged arguments, we'll consider all. This on 22nd June.
My lord. Obliged.
Supplementary list item 15.
My lord, in this case, there is an interim order continuing, but the entire promotion has been stalled, and the petitioner here in this case has retired since February 2020.
I'll, my lord, take 10 minutes. This came up on January 5th because it was passed on for the last matter, but couldn't reach on January 5th. I'll just take 10 minutes. This is actually covered by the Supreme Court orders.
No, here, in fact, I was verifying the prayer. Well, first prayer is for promotion because that can be granted now. But so far as validity to two rules, there I have to file counter affidavit.
Yes. So far as the first matter, the second prayer, the person is still in service. So in the first matter, there was a stay order. Now they are saying that since he has retired, let the stay be vacated. In the second matter,
so we vacate the stay in the first matter?
No, then the stay has to be granted in the next matter because both were tagged.
Kindly see the prayer.
No, they can't have. I am willing to argue the matter. It's covered by the Supreme Court orders. They have fairly stated before the Supreme Court that the exercise in terms of M. Nagaraj hasn't been done in the state of Orissa. So once, and if my lord wants straight away, I'll give that judgment. That is 2020-15 SCC 297. So after this, actually nothing remains. And here, there is no exercise in terms of M. Nagaraj. Hence, there cannot be any reservations in promotion. And this is for the subordinate judiciary. Let me kindly see paragraph 15. 2020-15 SCC 297. May I just place para 15? The learned counsel appearing for the state of Orissa has fairly submitted that after the 85th Constitution Amendment, by virtue of Article 16(4)(a) was amended, there is neither any legislation in the state of Orissa nor any executive order by the government.
Okay. Right. The lawyer went away for a minute. Okay. Right now, he's come back.
Yes.
So, bring that book, sorry.
No problem.
There is any executive to extend the benefit of promotion to reserve vacancies with consequential seniority. So in view of this, in terms of Nagaraj, UP Power, all those judgments, there cannot be any reservations in promotions in the state of Orissa. So this is the simple point that we are making. These concern the subordinate judiciary. If my lord wants, I have given a compilation. These are, I don't know whether they have been scanned, but they are a part of the records. All the judgments are there from M. Nagaraj to Jarnail Singh.
Can you wait till the end of the board? Let's run through the board and we'll come back.
Yes.
So here we have not filed the counter so far as validity.
On that.
It's a point of law. It can be answered on the basis. They have filed a counter on behalf of the state.
Yes.
It's a point of law covered by judgments. And
right. Anyway, end of the board. We'll just pass it over, take it and end of the board.
Item 16 also.
Yeah, 16 goes with it.
Supplementary list item 17.
None appears. Mr. Parija,
yes, sir.
We just saw a very young lawyer go past wearing a senior gown. See, all that exercise we're all undertaking has no meaning, sir. This is simply not stopping.
I'll check.
Look. Yes. Sorry. Yes, carry on.
Item 17 and 18, I've just received counter and I need to file a rejoinder there too. I pray for its time.
Counsel to the petitioner seeks and is granted time to file this. Counter also not filed?
No, counter filed. Counter filed.
Copy just now served on me.
Copy is a counter filed, be brought on record, rejoined by the next date. This on 29th August.
17 and 18. Supplementary item 19.
My lord, my senior Mr. Samuel is out of station. He is requested to list this matter on 4th of May.
What is special about 4th May?
He has requested to list this matter.
No. What is special about 4th May?
He told me. That's it.
18th May. So, Monty, you're not taking him for a ride or?
No, my lord, we have taken everything, my lord, pursuant my lord's direction.
That was a pun intended. He's unhappy with the state of the road.
No, my lord, now because of my lord's intervention, we have personally, I have visited the road. And now the all motorable condition, there is nothing, no potholes, nothing, my lord. Because and the development work is they have time file the last 15, they have filed the latest report. Before
on the next hearing, you do a video, at least of some stretches.
All right, man, that will be better.
At least a video. Okay.
All right. Also of that, I will produce.
All right. At the request of counsel, the petitioner list on
18th May.
18th May. All right.
Supplementary list item number 21.
At item 21, I'm in virtual mode. I received a copy of the counter today.
All right. Rejoin to be filed for the next date. What is the urgency here?
I am filing the counter in court today.
Oh, counsel for the
number 6. For the opposite party number 6.
All right. Counter of opposite party number 6 is. Mr. Mudri states that the counter affidavit of opposite party number 6 will be filed during the course of the day. Rejoin to be filed before the next day.
Well, I have already filed.
Okay. Yes, filed it today. That he has filed it today. 30th August.
Supplementary list item 22.
I am in virtual mode, my lord. I am for the petitioner, my lord. Last occasion, they have filed the counter at opposite party number 7 and 9 and 8. And they have categorically stated that the collector has called a convened a meeting and he has targeted the electricity matter, madam. In this case, I am suggesting, my lord, your lordship can direct the collector to cause an inquiry in presence of the petitioners as well as the public that they have disconnected the power supply from just now 12 p.m. to 12 p.m. to morning, my lord. So I pray, my lord, let
the collector has filed the affidavit stating that he has not instructed to TPC or Tata Power Northern Odisha Distribution Limited to disconnect the power supply.
I have not received any copy of
I have not received the counter filed by TPNODL, my lord. But the collector in the collector, my lord, I'm sorry, my lord, the assistant conservator forest, my lord, counter affidavit filed by OP number 8, my lord.
And the counter I have filed, my lord, for 7 and 9. We have taken a stand. And here the clear aberment that whenever there is a requirement and an instruction made by the energy department, our code is made. Not always, my lord. Not as per the allegations.
Every day, my lord. Every day night, my lord, that is now.
And the elephant corridor is in progress, your lordship. And that is the reason for this power.
These are summer months, sir. It must be gruelingly hot.
Yes, my lord.
And to have power cut every night means no sleep.
There is a my lord.
Whatever we have categorically stated that whenever instruction is made and requirement is made, when there is a movement of elephant, then there is a requirement only. And to get out of this problem, the state government has given finance and the work is in work footing manner is going on for the elephant corridor, so that this
No.
problem will be resolved.
Elephant corridor is one thing, the power cut is another, sir.
The power cut is made when there is a movement of elephant. That is the instruction of the energy department.
In the village, Malad, there is a corridor. No
So
corridor
whenever
is there in the village.
we get the input from the energy department that there is a movement of elephants in a particular locality.
No. Can you tell us which are the days you got such instructions?
Yes.
Which are the exact days you got that instruction?
It is maintained throughout the year, but there is the petition.
Please give us the precise dates on which you got such instruction, which made you switch off the electricity.
That is there. That must have been maintained there.
No, must have and all. Please give us that dates, exact dates.
And timing of
You are appearing for 9.
Yes,
Whom are you
7 and
appearing
9.
for, sir?
7 and 9.
You said the stand taken by the TPNODL in the affidavit dated, in the counter affidavit, dated the 5th April 2022 is that the power supply is switched off as and when instructions are received about movement of elephants in the area. The TNOPDL will file a further affidavit indicating for the months of March and April 2022, the number of days on which such instructions were received and the exact hours during which power supply was disconnected to the village in question. The supplementary affidavit shall be filed positively within 1 week.
May I pray one thing, my lord?
Malad, 13th, okay. List on 13th May.
Malad, may I pray one thing, my lord? Malad, during pendency of this writ application, my lord, Lordship may kindly direct the collector to cause an inquiry whether the disconnecting their power supply. Everything can be kept to landline.
There is a meeting convened by the collector, and all have participated. And the collector is before a Lordship.
In presence of the public, everything will be.
So I will also file affidavit, whatever Lordship directed, I will comply with that.
All right.
Supplementary list item number 24.
Oblige that.
I think we issued notice last time. Oh,
To the collector?
no.
No, 24 Lordship has not been admitted.
Yes.
I think it has already been against the revenue.
Right.
Asked earlier.
All right. Capital receipt. In view of the decision dated 18th December 2019, passed with this court in ITA 2 of 2016, the present appeal is dismissed. All right.
No password. Supplementary list passed to matter item number 15.
There's a compilation, my lords, of all the Supreme Court judgments. Point is very simple, that you can't have reservations in promotions unless you conduct a particular exercise. Now, my lord knows that in 1993 Supreme Court, page 477, para 700, clause 6 of Indra Shawni, they said that you can't have reservations in promotions. Now, to get over that, the
16.4a, Nagaraj.
Yes. Now, Nagaraj came in. Nagaraj laid down a certain set of conditions. You have to conduct this para 122 and 123. Thereafter, UP Power came in where they have said that unless you follow Nagaraj, you can't have this. UP Power was thereafter subsequently modified, and Nagaraj was also modified in Jarnail Singh. Jarnail Singh, what they said is, this is also a part of the compilation. They just said that so far as SCs and STs are concerned, that exercise of collection of data, that you need not do, but other things have to remain.
Which is what?
is that there has to be, for having reservations in promotions, you have to see whether this would lead to efficiency in your work.
Basically, some committee will have to be formed to study.
Yes. So now in the judgment which I showed in the beginning, the state of Orissa before the Supreme Court has said that we have not conducted this exercise in terms of Nagraj. So this is a 75 Act. In Orissa, the act which they are now implementing is a 1975 Act. So this exercise hasn't been done. They could have done after post Nagraj, post UP power. They have not done it. So now this concerns the subordinate judiciary. So if my lords would see, I'll quickly run through those paragraphs.
Well, since so far as the validity of the rule is concerned, we have not filed. I pray some more time to file.
They have challenged the validity of the rule.
Yes.
In this batch, in the last matter, they have filed counter. In this batch, item 16, in the last matter, they have filed a counter.
No, filed by the opposite party number 1.
By
not
state.
By the, no, state has not.
By the judiciary, I think he's appearing for both. That's the case.
My lords. So this is the point, simple point, my lords. It's all covered by these judgments. If my lord would just see this compilation. And then recently, Justice Nageshwara also has given a judgment that you can't have.
No, the interim order is what? That will be subject to the outcome.
No,
interim order is that
has been stalled.
Now, interim order is.
May I submit, my lord?
No, one minute. Let me just ask him. I just ask him.
Interim order is you don't give promotions on the basis of a select list where you have followed these impugned provisions. So if the interim order is vacated, in the second matter, juniors who are about say 7-8 years junior, they will be placed.
Suppose it's made subject to the outcome of the petition, then that's normally in service matters. That's the kind of interim order that's passed.
Normally it is done, but this order was passed seeing the flagrant violation of the Supreme Court order. So now they are not ready for hearing. Whenever this comes up, they take time. Now in the last matter, they have filed a counter addressing this issue, and before the Supreme Court, they have made a statement that we have not conducted this exercise.
There are two issues. Well, Article 16(4)(a) says so far as consequential seniority to be granted to reserve category candidates. Well, here this is not the provision for consequential seniority.
Yes.
That is the distinguishing factor. And at my place, Article 16(4)(a). Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class. And these are the important, with consequential seniority to any class. Whenever we will provide any consequential seniority and promotion to any specific class, there we have to come up with the new rule and with the quantified data. Well, this is not the case here.
What according to is the case here?
Here,
you can see the provision at page 96.
In the first matter, 15440?
Yes.
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 5. Reservations. Notwithstanding anything contained in these rules, reservation for vacancies for scheduled castes and scheduled tribes shall be made in accordance with the provisions of ORP Act 1975 and the rules made thereunder. We have never stated that there will be a consequential seniority.
No. But even promotion is there, covered by 44A. In the matters of promotion with consequential seniority.
Yes. No,
you are making a provision for reservation and promotion, sir.
No. It starts with nothing.
Yes, my lord.
It starts with nothing. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion.
Yes.
That is one part. And second part is with consequential seniority.
So you are anyway providing for reservation promotion.
No, that is not the case.
No, my lords, let them be very clear. I'll show my lords. My lord may see page 112. Page 112, how the state, my lords, is violating the order of the Supreme Court. My lord may see page 112 of the first case. Now, the opposite party for whom Mr. Das is appearing, my lord may see at page 112, Sarath Kumar Das, my lords. Yes. Now, my lord may kindly see his date of entry into government service is 19/8/97.
Yes.
Now, my lord, may just see the next page. Suresh Chandrapati, the petitioner, his date of entry into government service is 4/2/85. Now, if the judgment of the Supreme Court is implemented, then there is by no way, my lord, Mr. Sarath Das can be considered for promotion.
No. Question is, my lord, I have already got promotion and none of my promotion is under challenge in this case. May permitted
Now,
1 minute.
now the promotion to the next post, the post of Sri Rastadar is being considered.
Is going to the law without clarifying the facts in this case. May I be permitted, my lord?
Yes.
Yes, my lord. My lord, here is a case, my lord, as per the existing procedure of law and the Orissa Reservation and Vacancies Act 1975, I was appointed a junior clerk and given promotion to the post of senior clerk in 2009 and thereafter to a bench clerk 2 in 19/5/2012 and again to bench clerk 1 on 12/5/2014. All these promotions have not been challenged till date by any of the so-called seniors. So therefore, in the particular, when I now in the bench clerk 1 and the petitioner in this case retired in 2022 to 2020, he got promotion only to the post of bench clerk 2 and retired as a bench clerk 2. He has never come to the bench clerk 1. And now the next promotion available in the judiciary is this post of Sarastadar. And there is now there is nothing has been opened that yes, they're giving promotion to me. It's a premature petition I will submit in this way. What you want that I should not be given promotion to the post of Sarastadar. Now let him be eligible to be promotion for Sarastadar. He is in a bench clerk 2 and he is a retired employee. And even the second case also, the person, Mr. Imran Khan, he is also in the bench clerk 2. He has not come to the post of bench clerk 1. And none of my promotion. There is no question of reservation here. That is the fact of this case.
How have you got your promotion? Is it through a reservation or on your own merit?
Yes, because of the reservation, all this promotion has been given and none of these opposite parties as per the existing law.
So merely because they didn't challenge your earlier promotions, are they precluded from challenging your current promotion?
No, current promotion is also not on a challenge.
No. I think they have come at the stage of challenge to current promotion.
No. Prayer number A, may I read, my lord? The prayer number A.
The core issue is whether they are compliant with the Supreme Court judgments. That issue they are not answering.
To promote the OP number 3 to the post of Sarastadar. Where is the question of given promotion to me to the post of Sarastadar? How could my friend know that I am going to be promoted? This is a premature petition rather. He wants that I should not be given promotion to the post of Sarastadar. He is not questioning my promotion to the bench clerk 1.
No. Merely that is not an argument, Mr. Das. It doesn't mean that the earlier promotions are not challenged. Therefore, the next promotion can't be challenged. That can't be done.
No, there is no promotion to me. I am not a Sarastadar now. I am a bench
clerk. Now you're not. He's anticipating that you might get promoted.
My lord, now
because of your quota.
Retired, one anticipation, a writ petition in a service matter, my lord, in a case of promotion.
So when is your promotion due? Let us ask that question. When is your promotion due?
No, as on date, my lord, there is no, because the...
No. When is it due? When is it due? You must have completed so many years as bench
Yes, now it is due. I am due for promotion. But that does not mean I have no vested right to get a promotion unless until I have been considered.
No, that is why he's in court. So you can't say he cannot come to court, it's premature because it is imminent. Your promotion is imminent.
No, first of all, he must be eligible. He is not even eligible. Unless he is eligible to get a promotion, he can only challenge my promotion. He is not even eligible. He is one rank below. How could he challenge that? And moreover, he is retired from service in 2020.
The second man is there. My lord may see the disparity. This man is 10 years junior. He's 10 years junior to this person.
Retired already.
Yes.
My lord may see page 113.
First matter he has already retired.
First matter I have retired. My lord may see page 113.
No. So first matter anyway stays being vacated.
Yes.
In the second matter, what is your rank?
My lord, just below him. 10 years.
You're not in the zone, Mr. Mishra. This is the point he's making. You're not even in the zone.
My lord, if they follow the Supreme Court judgment, if they follow the Supreme Court judgment, then Mr. Sarath Das cannot be given further promotion in the gradation list.
No, but where do you keep the locus is the question.
My lord, in the gradation list, I am at par with them. That is what the Supreme Court says.
Where is that?
In the gradation list, my lord, may kindly see page 113. Page 113 of that page, of that first brief, my lord. Abdul Imran Khan is the other petitioner in the other writ. My lord, may kindly see his date of entry into service is 4/2/86. So, yes. My lord, if they are constitutionally compliant, if they follow the Supreme Court judgment, then a person who has entered much earlier, that is about 11 years ahead, would definitely be promoted. Just because they are not following the Supreme Court judgment, not one, but a series of judgments.
No. You will not come under quota, correct?
I will not come under.
In your own turn, when are you due for promotion?
If this judgment is implemented, then I would be promoted to this post.
No, would be meaning when? You're a bench clerk too, right?
My lord.
You can't straight away get promoted to Sarasdar.
No,
you have to become bench clerk 1, I suppose.
No, I think, my lords, that issue, my lords, in the gradation list, I'm just below him. And
no. Let me ask. One thing. Let's be clear, Mr. Mishra. For you, in your own quota,
my lords,
to get promoted as Sarasdar, you have to first get promoted as bench clerk 1, and only after you spend some years as bench clerk 1 can you get promoted as Sarasdar. Correct?
Yes.
You've nowhere reached that point. You forget about quota and his promotion, all that for a minute.
My lord.
If your chances of being promoted as Sarasdar are somehow going to be affected, then you have a locus. But you are nowhere there.
My lord, regarding this, that whether I would be eligible for the Sarasdar immediately.
You'll answer is no.
No, that I'll have to cross-check. I can't say.
Then you check. You are a bench clerk 2, correct?
I am a bench clerk too.
Then there's no question. You have to be there's no leapfrogging here. There's no double promotion here.
No, my lord, may kindly see, there are two grades. One is bench clerk grade 1 and equivalent posts. And I am, my lord's, bench clerk grade 2 and equivalent posts. In the gradation list, I'm just below him.
We'll see that this is a gradation list of that first entry stage.
My lord.
Meanwhile, he has got onto a different train. He's got to the SC/ST train. You're in the unreserved train.
My lord.
That train has gone ahead.
My lord.
You are still in the 2 platforms, 2 stations behind. In your train.
My lord.
You can't have a non-stop. The next stop is bench clerk 1 for you.
No, regarding
your train will stop there for a while.
Now, regarding this, whether I'm eligible for this post.
No. We are now on your locus. How are you questioning his possibility of his getting promoted as Sarasdar in an SC quota? How are you having a locus to challenge that?
I get that point, my lord. My lord may just allow me factually whether I'm eligible for this post or not. I get that point. Whether I'm eligible or not.
Immediately. Eligible in the long run is one thing. Eligible right now is another thing.
My lord, right now itself, for that only, my lord may give me some time. I'll just factually find that out.
But only that anyway, the first matter, you say, with the petitioner having retired, the question of continuing the interim order does not arise. Consequently, the interim order already passes, hereby vacated. And then you say, Mr. Mudali, this is all in the first petition. Mr. Mudali wants time to file a reply on the question of the validity of the rules. At his request, the reply be filed as a last opportunity, not later than 1st July, the 4th July, 2022. List on 10th August, 2022.
Another matter, my lord, WPC 444 of 18, there also, my lord, have vacated that interim order, a same matter. Another person, he has also retired, that is pending.
All right, 444 of
18.
It's not listed. So list along with WP Civil 444 of 2018 on August. What was it?
10th August.
10th August. WP Civil 20110 of 2019. Mr. Das appearing for the opposite party number 2.
3, my lord.
3. Questions the locus standi of the petitioner to challenge the likely promotion of opposite party number 3 as Sarasdar in the SC quota by pointing out that the petitioner is nowhere in the zone of consideration for such promotion, since he is at present only a bench clerk 2, correct?
Yes.
So what we'll do is, since we are recording the submission, Mr. Mishra, we'll vacate the interim order and we'll permit you to file an application in case you are imminent. It's imminent.
No, my lord may
In the second
my lord
case-
may not dispose of the matters.
No. In that way, the matter, the interim order is modified by directing that any promotion made of opposite party number 3 will be subject to the outcome of the writ petition.
Obliged. That
Then you say list on August 10th.
file.
But may I pray for a shorter date, my lords, because they have been taking time on this. This is an issue where other cases are also linked to this. It's a clear point where they have actually stated before the Supreme Court that this exercise hasn't been done.
Service matters, let it come.
That
No.
Supreme Court judgment is
Many
quite
other urgent
different
matters.
footing.
August 10th. All right. Can I suggest one thing? This compilation, you keep it with you because otherwise it all gets lost.
I would.
You hand it over in the next day.
Great.